Good evening, everyone, and welcome to our webinar. My name is Will Liner, and I'm an attorney with Disability Rights California. For a visual description, I am a middle-aged white man with dark hair, black glasses, and a blue sweater with a blue collared shirt underneath. My background is a Disability Rights California logo, and I wanted to thank everyone for joining us tonight. We are going to talk about a proposal from the Department of Developmental Services, or DDS for short, to change the complaint process about rights violations in the developmental disability system, how this proposal may impact people served by the system, and how to make your voice heard as this proposal gets closer to becoming law. And we are going to dive right in. Next slide, please. We have a few learning objectives for today's webinar. First, we are going to talk about why DDS is proposing to change the existing complaint process. People sometimes refer to this as a 4731 complaint because the law about these types of complaints can be found in section 4731 of the Welfare and Institutions Code. Then we're going to get into details about what changes DDS is proposing. Then we're going to talk about the things we know about these proposals, the things we don't know about these proposals. And when we do this, we're also going to share our opinions about what we think are positive, good things about the proposals, and also some concerns that we have. You are going to learn about when the proposed changes will take effect, if this proposal is approved. And finally, at the end, we're going to talk about how you can advocate for changes that are meaningful to you. And now I'm going to turn the presentation over to my colleague, Vivian, to talk about why this is all happening in the first place.
Thank you, Will, and good evening, everyone. My name is Vivian Hahn. I use she, her pronouns. I am also an attorney at Disability Rights California. I'm an Asian American woman with glasses and a stripy blouse with a blue DRC background. So why did DDS make this proposal? Why are they proposing to change the 4731 complaint process? And why are they proposing to replace it with a new process? So to give you some background, they are doing this because some new federal regulations are requiring them to do so. The new federal regulations are requiring all states to have new grievance systems in place by July 2026 that would enable people who use home and community-based services, like the types of services we get from regional centers, to have a way for people to file complaints if they think that certain providers or regional centers are not following the rules contained in what's known as the HCBS, or Home and Community-Based Services Settings Rule. Some of you in the audience may be familiar with the HCBS Settings Rule. That's an older federal regulation from 2014 that essentially described what it means for a service or setting to be integrated into the community, with the idea that every state's developmental disability services should meet these requirements. In 2024, after 10 years, the federal government wanted to create some additional processes that would help states make sure that people who get services were truly able to access those services in a timely way, and to make sure that the promise of the older rule, the HCBS Settings Rule, that states had a way of making that a reality in their states. So they had some requirements. DDS needed to comply with these new federal requirements, and they chose to do so by creating a new grievance process or complaint process. And at the same time, they had also been wanting to make some improvements to the existing 4731 complaint process. They felt that it was not as effective as it could be. And so they decided to kill two birds with one stone and address both of these needs into one proposal. So DDS's proposal to replace the 4731 process with a new process is designed to accomplish both purposes. It complies with a new federal regulation, and in DDS's point of view, it will make some much needed improvements or changes to the old 4731 process. Next slide. So one of the main concerns that people have, or questions that people have about this proposed change is, does this apply or will it affect fair hearings, or what is now referred to as Lanterman appeals? The short answer is no. This proposal will not apply to fair hearings or Lanterman appeals. It does not touch that process at all. Your rights to appeal a regional center decision regarding your eligibility or the types or amount of services that you get in your IPP, that process will stay the same. It's not going to change as a result of anything in this proposal. So very quickly, in order to help distinguish between these two types of complaints, if you are looking at applying for regional center services, the regional center said that you were not eligible, but you think you ought to be, that is something that you can still appeal through fair hearings, or what we often call Lanterman appeals. You can also still use that process if you asked your regional center to provide a service and the regional center said no, it's not necessary. Or for example, if the regional center would like to reduce the number of hours for a service that you may already be getting for your IPP, and you disagree, those are examples of things that would go through the appeals process. Those are different from what we now call 4731 complaints. Those are different types of complaints that do not have to do with eligibility or with the kinds of services that your regional center is offering you, but where you still feel like the law may not have been followed. For example, if a regional center agrees with you about what services you ought to be getting, but for whatever reason, you haven't been able to access those services. Or if you asked your service coordinator for an IPP meeting, but the regional center did not have an IPP meeting for you within the 30 days that's required by law. Those are just some examples of things that you would currently use the 4731 complaint process you would use that process to bring attention to some of those issues. But some of that will start to change in this new proposal. And for more, I will turn it over to my colleagues.
Thank you, Vivian, for that background and the distinction between appeals and complaints. The next two slides will take a further look at some of the things that we describe as the scope of a complaint or a grievance, meaning what are the sorts of things that can be brought up in a complaint or grievance. Under the current process, any right can be complained about for three broad categories of circumstances. If that right has been abused, punitively withheld, or unreasonably or improperly denied by a service provider or a regional center. So again, that encompasses any right that has been abused, withheld as a form of punishment, or improperly denied. And that can be presented as either against a regional center or a service provider. The federal rules perhaps expand this by acknowledging that a right may not necessarily yet be violated for someone to feel a sense of dissatisfaction with the way that their service providers or regional centers are helping to meet their needs. The new grievance process states that a consumer may file an expression of dissatisfaction with the performance of the federal rules, the home and community-based services rules, and the Lanterman Act's Bill of Rights and right to self-determination. So again, it's a statement of dissatisfaction. It doesn't necessarily require that a right has actually been violated, but if someone desires to express themselves about the way in which the regional center or provider is meeting their rights, they can use this process to help get some type of relief. And again, an important reminder that the appeals process is totally separate from this complaint or grievance proposal. The appeals process applies specifically to the nature or quantity of a service or eligibility determination. It does not apply to a whole host of other rights that people enjoy under the Lanterman Act. Next slide, please. To get into what the federal rules entail, it's essentially a set of lists. And these things may not necessarily seem so unfamiliar to any of us sitting here in this presentation as Californians. But the reality is that not all of the states enjoy these very simple protections, and the federal rules are designed to apply a nationwide standard for persons with developmental disabilities, whether or not they have a regional center system available to them. They include things like a person-centered plan, a process, written goals and written plans, services that are chosen by the person that support full community access and integration. Hopefully, none of these things come across as a surprise to any of us. They are already enshrined in California law. The Lanterman Act also includes specific protections known as the Bill of Rights, and we encourage each of you to refer to Welfare and Institutions Code 4502 to read the full list of rights. It gives you a sense of the way that things were before the Lanterman Act, some of the conditions that persons with developmental disabilities experienced, and an expression of rejection. We will not go back to times when people were left abandoned. We only move forward where people have the right to dignity, to privacy, to public education, and many other things that allow them to live a free and complete independent life. There's also the right to self-determination, which is not necessarily the same as the self-determination program. Here, I mean the right to be engaged in and to take ownership of the decisions that are being made about you. And lastly, there is a set of rights known as the Patient's Bill of Rights that applies to persons who find themselves residing in state-operated facilities. And those include the rights to own possessions, have privacy, have visitors, have access to telephone communications. If you are dissatisfied with the way in which any of these rights are being performed or met, then the grievance process may be something that you would want to consider for yourself. As to who would be able to file a grievance, here again, we see a very important improvement. Under the current 4731 complaint process, each consumer or any representative of a group of consumers, so again, a consumer or a group of consumers, may file a complaint. Under the proposed grievance process, a consumer or applicant or their authorized representative may file a grievance. This is very important. Under 4731, an applicant for services can only file an appeal, but they have other rights that are very valuable and very important that cannot be addressed by an appeal. Their right to timely processing, their right to a fair intake process, their language access rights, etc., are all things that may and should be able to be complained about if they are being violated or if you are dissatisfied with the performance thereof. Lastly, next, a person who has the consent of a consumer or applicant, if you have been authorized by a consumer, you may file a grievance on their behalf. And lastly, providers, so long as there is not a conflict of interest with the way that they relate to the consumer and the regional center. So this is who would be able to file a grievance. Again, under the new rules, it would be either the consumer or an applicant, a person who has the consent of a consumer or a provider, so long as there's no conflict of interest. Next, I'm going to pass it over to my colleague, Claudia Menjivar, to talk more about the process and the steps that an individual can take to file a grievance.
Thank you, Blas. My name is Claudia Menjivar. Short description, I am a Hispanic or Latina woman with light brown skin and dark brown hair that I have down right now. I'm wearing blue-rimmed glasses and a black turtleneck, and I have the DRC blue background. And thank you for joining us tonight. As Blas mentioned, I would like to talk a little bit about how some of the processes are changing on how complaints or grievances will be handled. So starting with where would a grievance be filed under this new proposal? So to refresh, with the 4731 complaint that currently exists, when you have a complaint that you want to submit, you're required to submit it to the executive director of the regional center that you belong to, where the service coordinator or provider violated your rights. And you're required to submit something in writing. Under this new proposed grievance process, one significant difference is that complaints or grievances will now have to be filed with the Department of Developmental Services, or DDS, which we'll refer to as DDS from here on out. Those grievances will be filed directly with the state. They will allow different methods of filing these grievances, including an online portal or form. You can also call and submit a complaint verbally over the phone, or again, you can submit something in writing. DDS will be responsible for receiving that grievance and then referring it to the regional center for further investigation and handling. What is positive about this proposed change is that it ensures that all grievances are received. They can't be rejected because they weren't filed with the right complaint process or with the wrong person, and DDS would have some oversight on whether regional centers are complying with timeliness requirements. Next slide, please. On that same note, there are some significant changes on the timeline and how these complaints or grievances will be responded to and handled. So currently, the current 4731 complaint process and what exists today, there's this general summary of timeline that I'd like to go through. So first, you submit your complaint with the regional center. The regional center director and their designee has 20 working days or about a month to investigate and resolve your complaint. They are then required to give you a written response by the end of those 20 working days. And then you, if you are dissatisfied with that response, will have 15 working days to appeal to the state, to DDS, for them to review the complaint. So again, you have about 3 weeks to then appeal if you're dissatisfied with the regional center's response. And then once you appeal the complaint to DDS, the state has 45 calendar days, or about a month and a half, to review your grievance and make any findings. So overall, this process takes somewhere around 2 to 3 months, potentially, depending on, whether they take the entire time or not. Now, the new proposed grievance process, if you look at it in totality, it actually takes almost about the same amount of time. So it's not going to necessarily make anything more delayed or more speedy, but it does significantly change how things are reviewed and how much time they're reviewed by. So with the new proposed grievance process, the regional center will now have 60 calendar days or 2 months to investigate any grievance and to then provide a resolution plan to address that grievance. And we're going to talk a little bit more about resolution plans. There also is the possibility for a 14-day extension under certain circumstances and with permission from the grievant. Once you get that regional center response and resolution plan, you will then have only 77 calendar days to appeal that to DDS, to the state, if you are unsatisfied with the response. And again, you may get a possible extension for good cause, again, adding potential time to this timeline. And then finally, DDS will have 21 calendar days to review your grievance and whether it complied with the process. So to summarize, under this new proposal, regional centers would have twice as much time to respond to your grievance now, and DDS would have to review these grievances much more quickly. So you can see how there's been a shift in how the responsibility is carried, whereas currently, right now, it's split pretty evenly with how much time each entity takes. Next slide, please. And then we mentioned resolution plans. So what is changing? So again, before we talk about the change, what is the current process for handling proposed resolutions or remedies when one files a 4731 complaint? The 4731 does not say much. Currently, it says that regional centers will investigate and propose the resolution. And then if you appeal a complaint to DDS, DDS is required to review and issue a, quote, final administrative decision, unquote. And the reason that's important is because that could include things like legal findings or review of the quality, for example, of what the regional center proposed. Under this new resolution plan proposed in the federal grievance rules, regional centers would investigate and develop the resolution plan, and it lays out some of the things that resolution plans may include, including this list captured here, bulleted, like the meeting of the IPP team, ongoing communications and meetings with the regional center to try to figure out resolutions, for example. A resolution plan that has steps that regional centers must complete, and potentially an outcome depending, or an outcome regarding the conclusions regarding violations of federal rules or state rules, etc. And then if you are unsatisfied with that resolution plan that the regional center proposes, you would then again have the option to appeal it to DDS. But here, DDS would only review for appropriateness relative to the grievance. It's a bit unclear what that means according to the proposed language, but it is not the same language as final administrative decision. So there's a bit of a question here on how much the department may have to review and what kind of things they're reviewing for in terms of the resolution plan. Next slide, please. So that was just some of the summaries of some of the process changes. There's a couple of additional things that we want to quickly cover that are new protections offered in this grievance process. One thing is that it does require regional centers to automatically provide access to people filing grievances, access to their records related to the grievance. So unlike right now, one has a right to access their case files, this one would automatically give folks access, and also not just to documents in their case file, but to documents related to the grievance. The new proposed rules also require regional centers to provide assistance, whether it means helping people fill out forms or understanding the process once it's requested from the regional center. It also offers people who are complaining or filing these grievances an opportunity to present their evidence. So to break that down into an easier way of explaining it, it offers folks the ability to be heard directly by the reviewer, by the regional center, to present their evidence, to have a conversation, because right now 4731s usually are decided just based on the records. There's never a call to the complainant to find out more about their side of the story. And these new proposed grievance processes also explicitly require that there be retaliation protection. So there's now anti-retaliation protections included in the law. Those were always required, but now they're explicitly added as part of the grievance process and is required by federal law. So now I'll switch over to my colleague to continue.
Thank you, Claudia. This is Will Niner again. Our team at Disability Rights California has spent a lot of time looking at this proposal, and the next two slides will cover some of the things we think are good about the proposal, and also questions and concerns that we have about the proposal too. But I want to start with the things that we think are relatively positive. Let's start with centralized tracking. We'd like that there would be centralized tracking under this proposal. Right? In other words, all grievances now go through DDS. DDS is the state agency that oversees regional centers. Regional centers will still have the opportunity to first resolve the grievance at the local level, but DDS sees them all. They'll have more information about the types of grievances that people are filing. And we hope, and DDS has said, that this will allow them to better track patterns and trends, like problems across the system, in order to make our system better as a whole beyond any one individual case. So we like that things are centralized. We also think that having just one system for grievances rather than multiple systems with their own ways of processing requests, that's also a good thing. Theoretically, DDS could have had one process for Enactment Act violations. They could have kept the 4731 complaint process, and they could have created a whole new process to cover these kind of grievances related to federal rules. That would have been confusing. People wouldn't have known which process to use when. So we'd like to think of having one centralized approach as a good example of a no wrong door practice. What else do we like? Claudia just talked about this. We'd like that the new proposal would explicitly give people the option to file grievances in writing through an online portal. through spoken language. So more ways to file grievances. That is a good thing to us. We talked about this earlier too, about scope. What are the types of issues that people can file grievances about? So under the current law, you would need to point to a specific legal violation of rights that would form the basis for a 4731 complaint. But under this new proposal, you could file a grievance based on dissatisfaction with performance about a particular legal requirement. So people can file grievances about more things. And again, we think that's a good thing. And Claudia also mentioned that under this new process, people who are applicants for regional center services will now be protected by these rights related to filing grievances. Under current law, if someone tries to file a complaint because they think that the intake process for eligibility is lasting too long and violating legal timelines, right now they don't have many good options, but now applicants would be able to file grievances too. More things we like that under the new proposal, there are now more explicit standards about what it means to be a grievance reviewer and who gets to review grievances that are filed. So under the new proposal, the regional center reviewer would be required to have subject matter expertise about the topic of the grievance. And the grievance reviewer also cannot have been involved in the decision-making or situation that led a person to file a grievance. So if they're involved in the decision-making, if the grievance is about that person or related to decision-making from that person cannot be a reviewer of the grievance. And one more good thing about this process, it's more explicitly designed to be more accessible and empowering to people. People would be entitled to reasonable assistance to help them file a grievance. They would get automatic access to records that the regional center used when investigating their grievance. And like Claudia talked about, they're also guaranteed an opportunity to tell their side of the story if they want, beyond the initial filing of the grievance. And next slide, please. We also have some questions and concerns about the proposal. Claudia talked about timelines. People may have to wait longer for regional centers to resolve their grievances and offer a resolution. In some cases now up to 60 days. And our hope is that regional centers will use this extra time to more fairly investigate your grievances and come up with better resolutions than might currently exist today. But like right now, sitting here at my desk today, I don't know if we can say that will for sure be the case. Other questions we have and potential concerns, when we look at the language about scope of grievances or the topics about what people can file grievances about, they might be narrower than what currently exists today. Blas talked about this a little bit. Under current law, people can file a complaint when any right has been violated by a regional center or service provider. That's really broad. But under the new proposal, grievances can be filed for violations of some very specific rights that Blas talked about that are contained in 3 sections of the Management Act. And some questions we have are, what about other rights that people have in other sections of the Management Act? Will those still be included under this new process? We hope so, but it's not clear when looking at the statutory language in DDS's proposal. The third big question we have is about resolution plans. And resolution plans, I want to say, this is the heart of the grievance process, right? You're harmed in some way, and you want the regional center to make things right. And to us, a good resolution plan means 2 things. It means that a regional center makes sure that the harm doesn't happen again in the future. So we want to fix things moving forward. But we also think the regional center needs to ask, did you lose services because of the harm? How do we make it up to you? And under the current proposal, there are only a few examples of what can be in a resolution plan. And it includes things like convening the IPP team or making sure there's ongoing communications between the regional center and the person. And that's, to us, that doesn't really hit the mark about what makes a meaningful resolution plan for people. We have open questions about the role of DDS and enforcement. People will still have the right to ask DDS to review the resolution plan if they're unhappy with it. But under this proposal, it just says DDS will review the resolution plan for appropriateness relative to the grievance. I'm not sure what that means. I'm not sure if it's clear to all of you what that means. It's a very vague standard. So we have questions about how DDS might apply that standard. Similar vagueness about conflicts of interest. The proposal says that someone's service provider can file a grievance on behalf of the person unless there's a conflict of interest. That's not defined anywhere in the current proposal. And we think that that may lead to a lot of confusion from people and the providers who want to support them. And lastly, we heard earlier from Vivian that DDS's intent in this proposal is to make the complaint process more meaningful to people and to help them get better individual resolutions. But a question we're thinking about and grappling with, and I hope all of you will as well, is to ask, does this proposal, do these things make this vision a reality? A grievance process that will lead to better individual resolutions for people served? I'm not sure, right? And I'd love to think more about what kind of changes to this proposal would be needed to make that happen. And with that said, I'm going to pass things back to Vivian, who's going to talk more about when these proposals may go into effect, but also if you have questions or concerns or ideas about this proposal, how you can make your voice heard.
Thanks so much, Will. So, when would this new proposal go into effect? If this proposal goes through and is finalized and approved and it's passed into law, it would go into effect as of July 1st, 2026. So what that means as a practical matter is that if you filed a 4731 complaint before July 1st of this year, those complaints would follow the rules that currently exist now under the existing 4731 complaint process. Any complaints or grievances filed on or after July 1st of this year would follow the new rules that we've just been talking about tonight. Next slide. But it's important to point out that these proposed changes, they are a draft. They are not final yet. What we know is that some kinds of changes will be going through. California needs to do that. Federal regulations are requiring it. So we do need to do something. But there is still time to reach out to DDS, to reach out to the legislature and tell them what we think about DDS's proposal for doing so. If you have questions, if you have concerns, if there are things that you think need to be added or addressed in the proposal that you don't see and you want those things to be added, you can do something about that. We can tell the government the changes that we want. We can advocate for them. and lifting your voices up is one way to make sure that this proposal will actually result in better solutions and more meaningful changes for your lives. I see in the chat that some people talked about holding regional centers and vendors accountable and having a better understanding of how those things will work. And so if those are just some examples of comments that you can make and that you can share to the legislature. And there are two key subcommittees of the legislature where we would recommend you provide those comments and questions. You can go to, in the Senate, there is a subcommittee called Senate Budget Subcommittee number 3 on Health and Human Services. And in the Assembly, there's a Budget Subcommittee number 2 on Human Services. And those are really the two key places that you want to be targeting your feedback. Next slide. Those two subcommittees will be having hearings on this proposal and also many other proposals, but definitely this proposal in the very near future. I'll tell you about the dates of those hearings in just a little bit. First, we wanted to give you just a quick overview of where we are in the state budget process. So in January, the governor releases his proposed budget, or kind of the first draft of the changes that the state wants to make through the budget process. And that's what we just reviewed with you tonight. This is DDS's proposal. It's their first draft. So the legislature will have hearings where people will have the opportunity to ask questions about that proposal and have some discussion to make sure that the proposals are doing the right things. In the middle of May, the governor has to put out what we call the May revision, which is essentially the second draft, right, or a revised draft of all the different proposals that they've put out. More hearings are held in the legislature. And then by the middle of June, the legislature is required by the Constitution, the state constitution, they are required to enact a final draft of these proposals into law. And then whatever that final version is that's enacted into law, it will go into effect on July 1st. So this may give you a sense of where we are in that process. In short, there is still time for DRC and especially for you in the community to tell the legislature and DDS what you think of their proposal and what you would like to see out of it. What's most important to you? Next slide. And yes, and before I turn it back over to my colleagues, I did also want to point out that I wanted to talk about, the budget subcommittee hearings. And if Sabrina, if I could ask you to put some information into the chat for everyone about the two subcommittees, the dates that they will be having hearings on this proposal. The Senate will be having its hearing at the end of March, and the Assembly will be having its hearing on this proposal in April. So that's one place where you can actually speak up. If you are able to attend in person, you can speak up and share your comments there. If you're not able to attend in person, you can watch online. You can live stream that hearing as it happens. And then later on, if you're not able to watch in real time, they do post recordings of the hearings and you will be able to access them online. There are also places where you can email your comments or feedback to the legislature, and we can share that information with you all in the chat as well. So those are just some options for you. All right. Now I will turn it over to my colleagues. If you want to go maybe back one slide, I will go over this particular slide. So as we come close to wrapping up, we just wanted to revisit the learning objectives that we outlined at the beginning of our time together. So tonight, we talked about why DDS is proposing to change the existing complaint process. We also went into more detail about what specific changes are being proposed, what we know and what we don't know about DDS's proposals. There are definitely some questions that are still left unanswered and aren't quite clear yet. We talked about when the proposed changes would take effect. And we also touched on what you can do, what steps you can take to advocate for the changes that you might want to see in this new process, and to make sure that it is a system that is meaningful to you. And now I will turn it over to my colleague, Sabrina.
Good evening, everyone. My name is Sabrina Epstein, and I'm going to be facilitating the Q&A this evening. If you would like to ask a question, you have two options. You can click on the raise hand button and be called on to answer your question live. The option to raise your hand is under reactions at the bottom or top of your screen. Click on reactions, then click on the raise your hand button. If you choose this option, we will call on you and give you the ability to unmute yourself to ask your question. You must unmute yourself, and if you do not have access to the Zoom video controls and are calling by phone, you can use *6 to mute and unmute, and *9 to raise your hand. Second, you can type your question into the Q&A. Some reminders when asking questions is that you should be mindful about what personal information you share. This town hall is recorded and is going to be available. It's optional for you to share your name or to turn on your camera. And if you have questions related to your own situation, your own case that you would like for DRC to weigh in on, that is better suited for our intake line, which you can reach at 1-800-776-5746. So with that, we can take the slides down, and I see we already have several questions in the chat and a raised hand, so I will start with those. The first question is, can a regional center staff file a complaint if they have the consent of the consumer?
That's a good question. I would like to think so. I think based on the new rules or the language that DDS has posted, I think it should be allowable, but it's a good question. I would want to ask DDS that question just to get clarification from them to confirm that that would be possible. But thank you for bringing that up.
And Vivian, I can add just one more point to that if it's okay. Under the new rules, people have a right to reasonable assistance in order to file their grievance. So if we're talking about a situation where someone wants to file a complaint but needs help doing so and needs help from their regional center to do so, a regional center could help facilitate filing that complaint, right, for that person. So if that's what we're getting at, I would say yes, but I think it is an open question about if a person can say, hey, regional center, like I want you to be the person who files this for me and represents me in that process, that may be much more difficult to do under these new rules, but it's an open question.
The next question is, what happens when regional center does determine that a vendor violated a consumer's rights? How are vendors held accountable? Is there anything in this new proposal that addresses accountability for vendors if they violate a consumer's rights? Will, do you want to start with that one, or Floss?
I can take that. Yes. I think the answer is a fairly clear yes. Under the definition of grievance under proposed Welfare and Institutions Code section 4890, you may file a grievance as an expression of dissatisfaction with the regional center, the service provider, or state-operated facilities' performance of any of the rights that we described earlier in the section on the scope of the grievance.
And thanks for that pause. If I could add a few things, we talked a bit about what types of things go into resolution plans. And right now, what the current proposal says is that resolution plans can include, IPPT meetings. It can include ongoing meetings with regional centers. It's not really specific about what can be in those plans. And we would sure like to see and will likely advocate for more examples of the types of resolution plans that can be put in place. And that may include like more stringent resolution plans to ensure that providers, that the complaint is against a provider, doesn't continue to violate somebody's rights. So I think that there are ways that we can think about like more examples that people can look to in the law about what resolution plans can actually mean if we keep using the frame of how do we want resolution plans to make a difference in people's lives if we don't say more about accountability and enforcement for those resolution plans. I'm not quite sure how we're meeting that mark.
Yeah, and I would just add one more thing, which is that, I mean, this all comes down to, right, if you file a complaint, you want to know, what will I get out of it in the end, right? If it's determined that I was right and, some kind of rule was violated, or a regional center or a vendor did one of these things that's covered that they shouldn't have, how will that problem or error be fixed, right? How will it be fixed for me? Two, if there was some kind of harm or loss, right? I didn't get something that I really needed when I needed it. How will it be made up to me, right? What can be done to make up to me, like what I lost or the way that I may have been harmed. And then the third is, what will be done, if anything, to make sure that this kind of thing doesn't happen again to anybody else, right? What will be done to try to make sure that this kind of thing doesn't get repeated? So these are some basic questions that I agree with those of you who have made comments, but these are fair questions to ask of the process, like how will it work? None of that right now is stated clearly in the statutory language that DDS has posted. And not all of these details have to go into the law, so to speak. But I think it's fair to say that the DDS and regional centers should have a plan, and there should be clear expectations that are shared by them and by us as to how all of this is supposed to work.
And there's a similar question. If a provider violates a consumer's rights, how do we get a provider to no longer be a vendor of the regional centers? I think we can say that's outside of the scope of this kind of complaint, but DDS will now have to track complaints more systemically. So there could be potential for additional action if there's a lot of complaints against the same person, for example. but there's no guarantee of it.
Yes, and I will say that there already right now, there already exists a separate process at the regional center level for complaints about vendors. So that would be a separate process, and that is one, right, that is one possible avenue. But those are specific to each regional center. I think that process varies from regional center to regional center. The benefit to this proposed new process is that, as we mentioned at the beginning, every single complaint will be logged by DDS and tracked. So they would be able to see, as Sabrina said, if there are any patterns, right? If a particular vendor has repeated or multiple types of complaints filed against them. And so I think there may be some opportunity to ask, well, DDS, if you see those kinds of patterns, what are the types of things that you might do about that in response?
I am going to turn to the raised hand. Melissa, you should be able to unmute yourself.
Hi. I just had a frustrating situation with a number of 4731 complaints that I filed against one specific regional center for failure to hold IPP meetings. And it's very straightforward because I requested it and it didn't happen within 30 days. So on behalf of my clients, I think it was about 5 clients, the same regional center, at different times over maybe 3 or 4 months, I filed 4731 complaints. The regional center came back and said, yes, we violated your rights. We're sorry. We're very busy. We didn't have time. We didn't have time to read your emails. And we will do education. That was their response. So then I appealed to DDS, and DDS said, you're right, the rights were violated. Regional center, you need to have a plan of correction, I think is what they call it. You need to submit a plan of correction. I wasn't able to see the plan of correction. I was just informed that the plan of correction was submitted. However, this regional center continues to fail to have timely IPP meetings for my clients and other clients that I have heard about. So I guess the bottom line is my question, I think Will might have answered it. How do we advocate to not allow in this new process the regional centers just to sort of say, we'll do education and that's sufficient, because it's obviously the underlying issue is not fixed. I mean, once I filed the complaint, they did hold the IPP meetings, which I guess was good. But I still had to file the complaint to have the IPP meeting.
Hi, Melissa, and thank you for raising this point. I will say that when we spoke with DDS about this proposal not that long ago, we asked a question very similar to yours. And I will say that the department has acknowledged that what you describe is just, requiring training of regional center staff, which has been a very common response when a right has been violated, that they agree that in the past that has not cut it. And as you described, it just has not been enough to ensure that the same types of problems don't keep happening again. So I think they would acknowledge that something different needs to be done. I don't think they would dispute that. The real question is, what would that be? And as of right now, I don't see anything in the proposed law that addresses that at all. We don't have any information about it. And like I said, it's not that every single detail needs to be included in a new law. I do think, however, that if you feel strongly about this, and if anyone else feels strongly about this, about what needs to be clearer and more specific, like what do you want to get out of this to prevent the same types of problems from happening again and again, that is something that you could and should express to DDS as well as to the legislature. And it may be possible to say something about that in the proposed law. And if you think that it would be helpful, for example, for any upcoming directives to flesh that out some more, that is also something else that you could ask the legislature or DDS for. And of course, please feel free to follow up with us here at DRC as well. And if you have thoughts along those lines, we'd love to hear from you too, Melissa and everyone on this call.
So I think we will take just one or two more questions. The next one is how is an investigation completed? And this person goes on to describe how, in their experience with the 4731 complaint, they did not have a chance to give their side of the story.
I'll take that one. This is Claudia again. So right now under the 4731, the DDS and to some extent, maybe the regional centers have some internal processes for how they handle complaints. None of it is actually contained in law though. So one somewhat positive thing about these the proposed grievance is that it offers a couple of new things. Like we said, it requires that documents be provided. It requires that you have an opportunity to present your case, to be heard, in person or to have an opportunity to discuss your case essentially with the regional center. But beyond that, there isn't much more on what the investigation will actually entail. And that is one concern we have, is again, how will this actually be implemented to the extent that regional centers will now have to potentially do more to investigate or to do more to do a thorough resolution plan. We haven't seen yet in either statute or proposed guidance or anything how regional centers will actually implement that. And so that is a concern we have, is that although there are some additional guidance on how to conduct an investigation, we still don't think it really goes as far as it needs to provide actual guidance to regional centers on how to ensure that investigations are neutral, that they're fair, that they protect things like privacy. I know there was another question about information being shared. Again, an investigation should have some pretty clear guidelines on privacy protections and things like that. But currently, it's not codified in law in the 4731, and we don't see much of that in the proposal as well.
Thank you, Claudia. I'll add one more thing about an additional safeguard to make sure that the investigations are actually happening the way they should be happening. So DDS is required to track data about the investigation process that regional centers do. And that data includes, the date that grievances were filed, a brief summary of the grievance that was filed, the dates of any kind of review meetings when people have a chance to tell their side of the story, and the resolution that was offered and the date of that resolution. And the federal government, remember these changes are being driven by the federal rules, require DDS to maintain this information so that they can show that the process itself, that data is being kept, that the steps that are supposed to be happening are happening. I'm not saying that will mean it's perfect every time, but it's another kind of data collection requirement and state safeguard where the federal government wants to make sure that they're seeing that our state system is doing what it's supposed to do with this new process too.
Thanks. I think that we are just at time. Before we wrap up, I wanted to say that yes, the slides from the presentation will be shared as well as the recording. It will take a little bit of time to get it accessible with captions and translations. So you will not get it tomorrow, but you will get it soon. And thank you so much this evening for your presence and for the excellent questions. It's been really great to spend the evening learning about the changes to the complaint process with all of you. Have a good evening.